The regular meeting of the members of the New York State Liquor Authority. In attendance are Commissioner Green, Commissioner Kim, staff in attendance, General Counsel Flug, and myself, Deputy Commissioner O'Brien. The next regular meeting dates are Tuesday, April 21st, and Tuesday, May 5th. All meetings are held in the New York City office. Video conferencing will be available at our other office locations. Items will be called in the order as they were signed in. First in Buffalo, then Albany, and then here in New York City. When your matter has been called, please approach the podium and state your name clearly. As a matter of courtesy, please silence your cell phones. First item up is 746 in Buffalo.
Okay. Good morning, Robert Heil, consultant.
Good morning, Kenichi McCarter.
Carrie, this is 746?
746. Poise Inc.
Okay, I have it, thanks. Good morning.
Good morning.
Good morning.
Do you have any relationship with the previous owner, Neil Radis?
No relationship.
How is your operation going to be any different from what was there previously, since the previous owner had his license canceled?
I'm trying to bring more of an upscale to this location, clean up the area. We're looking for an older crowd. We're also going to bring a restaurant to that location. I'm looking for more of a 30 and over crowd, and I'm also catering to family during the day, during the restaurant hours.
I'm sorry, your application indicates that you're going to have live music and dancing, but nowhere in your diagram do you show a space for dancing or for live music.
There's areas in the location where they can set up for like a live band.
It's not in your diagram on your application.
We can alter the diagram. The live music is not something that they're looking to do on a daily basis, but there will be live music possibly on some of the weekends, so we wanted to put that on the application. But there's not a formal dance floor or a stage. That's not really the business plan. It's more of a restaurant, but we will have the availability of bringing in a small jazz combo trio. It's not going to be like an 8-piece band setup at all, just small light entertainment on the weekends.
What are your proposed hours?
During the week, I would like to close at 12 o'clock p.m. and on the weekend, 2 o'clock a.m. at the latest. And we'll open up during lunchtime.
Ms. McCarter, you have submitted a personal questionnaire. This is the first venture you're actually going to own and manage that has entertainment, a liquor license. Are you going to have a manager or someone assist you operating the location?
Yes, I will.
And who will that be?
I have a cousin that has a degree in management, and she's going to help me out. So she's going to be working there. But in the beginning, I'm going to be there from open to close, hands-on.
And you're no longer going to have, you're going to resign from your day position?
Yes, I am.
All right. You mentioned that you're going to have it's going to be food. It's not a full restaurant, correct?
It will be. Yes, it will.
You're going to have a full restaurant during those hours?
Yes, ma'am.
Food will be offered, the menu that you submitted?
Yes.
That you have an award-winning barbecue. Where did those awards generate from?
Well, my aunt, she makes the best barbecue in our family, so we consider her the award-winning because she's going to be cooking in the kitchen for me.
Okay. Because I saw you were out of the state, so I thought, the Texas connection. So basically, what I'm concerned about really is the hours of operation. You want to be operating until 2 a.m. Are you going to have security at this location?
Yes, I will have security. There's a company that I want to go through. I'm not looking for that type of crowd either where I would need security, but if need be, I will have them on the weekends. But I'm looking for more of an upscale, older crowd that I'm trying to cater to.
But you also, I'm sorry, Commissioner.
Are you only going to have jazz music?
I'm not going to have live music a lot occasionally, but I would like a nice jazz band when I do offer live music.
But you're going to have a DJ as well?
No DJ.
None? Okay. Chad.
I'm sorry, but you're just saying that your location's going to be a whole lot of things. During the day, it's going to be a family place, but I don't see anything here that, on your menu, that addresses children or families, and in fact, you call it dinners under the entrees. And then at night, you're trying to be a 30s crowd with music, without music. I just don't see anything in your application that supports the statement that during the daytime, you're a family lunch restaurant.
We only supplied the dinner menu. I apologize for that. But there is a lighter fare menu that we can give you for the daytime and lunch crowd.
So what's on that menu?
More the sandwich, panini, salad type of items, utilizing basically the same food elements that are in the dinner menu.
And how early is that that menu's offered? Is that starting at 11 or?
It's going to start at 12 o'clock.
So do you foresee most of your revenue coming in from the over 30s crowd later in the evening, or from your lunch and dinner crowd?
Lunch and dinner crowd, I see it.
So then would you have an issue with closing earlier on weekends?
No, I wouldn't have an issue with that.
How early?
I think at least 1 a.m., because I don't think there's a need for 2 a.m. if
Friday,
it's a
Saturday.
family restaurant.
Friday, Saturday?
Friday, Saturday, and midnight's fine for the weekdays.
Mm.
And we could start there, and then, happy to review after 6 months or a year of operation.
Okay.
We're having no previous experience in this industry. We just want to make sure that because this location has had issues before, that you are going to operate the way you're proposing to operate.
Yes, I don't have a problem with that at all.
All right. I'll be ready to vote in a second, but the manager that you're going to select to assist you, I know it's family, but I still would like a personal questionnaire submitted on that individual. And you're willing to close at midnight, I guess, Sunday to Thursday, and Friday to Saturday, you'll be open until 1. You'll agree to those hours?
Yes, ma'am.
Okay. And food has to be offered the entire time that you're open?
Definitely.
Okay, I'm ready to vote.
Okay.
I'll approve with those conditions, with those specific hours, and to submit your personal questionnaire for your manager. So I'll approve.
I agree with Commissioner Green's stipulations.
Good luck.
Thank you very much.
740, Mr. Moe's Liquor and Spirits.
Mohsen Mansour, good morning.
Good morning. Is there any protest there in Buffalo?
There's no objections here in Buffalo.
Okay, thank you.
7.
Oh, sorry. We did receive a protest.
Yeah, I said okay.
The store is like 4,500 square feet.
Yeah. I think, did we get any response from the nearest store? Refer to enforcement,
I will double check, Jim.
but otherwise I'm good.
No, we have not.
No.
Okay,
All right.
I'm ready to vote. I approve.
I approve.
Thank you, I appreciate it.
Good luck.
Good luck.
Thank you.
741, State Street Liquor and Wine. Oh, I'm sorry, Michelle, is there anybody left in Buffalo?
There's no one left in Buffalo.
Thank you. State Street Liquor and Wine.
Morning, Commissioner Green, Commissioner Kim, members of the board.
Good morning.
Sean May here, appearing with Mrs. Lee and Mr. Lynn of State Street Liquor and Wine. This is a application for a package store in Schenectady. There was previously a package store there up until a few months ago. Mrs. Lee was the landlord. That business was, they evicted the tenants, basically. It was an issue where business relationship wasn't working out. So this application is just to put a new liquor store in the same location that was there prior.
Anyone in Albany in opposition?
No, there's not.
Okay, we did receive a letter in opposition from, I believe, King Cork.
So who is the owner of Shanghai Bistro?
Mrs. Lee.
Okay, so Shanghai Bistro has a terrible history, and the license was revoked in 2007.
Yes, Commissioner Kim. There was an issue back in 2006. Mrs. Lee had the Shanghai Bistro, and at night the location attracted a particular crowd that they just weren't experienced or ready to handle it. By our own admission, they just did not have the experience to handle that type of crowd that was attracted to the restaurant at that time. We're not trying to go in and open another restaurant. This is purely an off-premises package store. Mrs. Lee's been the landlord. This is their only source of income, this building, and they're looking to operate this business into retirement. We certainly don't anticipate any problems along those lines, or any lines, actually. It's been a learning experience for sure. And Mr. Lin, Mrs. Lee's husband, will be involved in the day-to-day operation as well. They understand about sales to intoxicated people, sales to minors. They're going to be getting a scanner for ID cards. They're very serious about the business. As I said, they're looking to do something into retirement, and this is their only location.
Well, how do you address the fact that out of the 1, 2, 3, 4 closest stores, all of them are showing a decline in sales over the past 4 years, consistent decline in sales?
Well, I see the letter from King Cork. The decline in sales. Mr. Lin actually worked at the store while they were the landlord during the past year. He understands the business, and he understands the business was doing very well. It's a viable business. I'm not sure what's going on with the other stores, Commissioner. I can note that King Court, the one that objected, it's a mile and a half down Route 5 on the other side of Route 7. They're in the Crosstown Plaza. We're near the Mohawk Commons. We think a store in this location, as demonstrated by the business that was there last year, is in the public convenience and advantage, and was doing good business last year.
Doing very good.
I'm going to approve the application, but just want you to acknowledge that you've had a serious history with the authority. Your license was revoked in 2007. That was an on-premise. This is a full liquor license. Your obligation to scan IDs and make sure that you're not engaging in underage sales. You'll lose your license a lot faster if it was there. The distances between the next closer stores are reasonable. This location was just licensed not too long ago, so I approve.
Thank you, Commissioner.
Thank you.
I'm actually going to have to disagree. I think based on the character and fitness, the history, and also the 4 closest within 3 miles, they're all showing all 4 of them year by year decline in sales. I think it's a sign of saturation in the area, and so I'm going to have to.
Commissioner Kitten, could you just consider that understanding the character and fitness, this is a different kind of location. The problem that they had in the past with the on-premises, like I said, was due to some naivety. They did not have the experience. It's 9 years later. They've been a landlord of the location. Mr. Lin has worked in the location. They understand the severity of the issues in the past, but we're in a different page here. There's no connection with the prior on-premises liquor license, which in 2006 in Schenectady, that was a trouble area. I think there were, from my review, there were a number of revocations back then. Not that that excuses anything, but this is a completely different ballgame with the off-premises license. If we could come up with some conditions or anything like that, it's not the same.
I think if it were just that, then I would reconsider. But I think just based on what's going on in that area, I don't see any reason to approve another store.
Even though this location near the Mohawk Commons did very good business last year, this area can support this business.
And I'm going to stay with my decision.
Thank you.
706, 2169 Central Limited.
We have to.
Good morning, Commissioner Green. Good morning, Commissioner Kim. Stephen Denegris, attorney at law for 2169 Central.
Good morning.
What is the DBA of your client?
Shenanigans.
Is there a reason it's not on file with the authority?
I don't know, ma'am.
They've been licensed since 2003.
They actually listed it on their original application, but said the applicant may do business under the name Shenanigans. However, this has not yet been determined. So we didn't put it on, but they did somewhat say that. I don't know if we have a certificate of assumed name.
Members, as to case 95520, which is calendar number 706, counsel's office wishes to withdraw that case.
Okay. All right. All the charges?
All the charges.
Which case is this?
706.
Oh, you withdraw?
Yes.
Okay. Withdrawn. We have two others with this license.
Yeah, this
It's
is-
actually 783B and C. Can we call those?
Yes.
783B and 783C.
Counsel, would you like to be heard on, let's take 783B. This
Yes,
is
yes, Commissioner.
number 88096.
Yes, Commissioner, thank you. I thought I submitted a fairly descriptive and fairly thorough contravention of the facts there for the authority to consider. And basically, I wanted to bring to the authority's attention that even if the authority were to sustain those charges, we've done some fairly aggressive things to try and live up to both the spirit and the letter of the law since those incidents occurred, and that included putting on additional staff. It included on doing patrols in the parking lot. It included on more aggressive screening of patrons. And since 2013, we have not had any more referrals from the Colony Police Department or any additional charges, albeit one that involved an internet. We left out a number apparently on an internet site, but there have not been any further referrals from the Colony Police Department in all of 2014 for any disorderly premises or any other additional problems or any arrests or any other violation of law. And we would ask the authority to consider that if it determines to impose a penalty on the other charges and to mitigate that penalty.
Sir, is your client here with you today?
No, he's not, ma'am.
And the person who attended all the hearings wasn't your client. The person was the former owner, now landlord/consultant to your client. That's correct?
That's correct, ma'am. Yes, ma'am.
Why?
Why?
Yes.
He was one of the people most knowledgeable about the operation of the business. That's why. And he also had a first-hand knowledge about some of the incidents.
Well, he seems to be the person who's running the entire business, and your client, whose livelihood and license is on the line, hasn't showed up at the hearings and hasn't showed up here today, and this landlord/consultant, former owner, seems to be running the entire business.
Well, that's not, well, I understand that. He's sort of a shift supervisor at the times there, but also the licensee had a serious back injury several years ago, and that has taken a little bit of the steam out of his sales there on appearing at some of these things.
All right, let's do this. I don't see a questionnaire on file for this consultant. Can we have your client and the consultant appear at the next board meeting?
Yes, ma'am.
And I'm sorry, we have a police referral here from December 12th of 2014.
That's news to me if there is one.
From December 14,
Yes,
2014?
yes.
Was that I believe that's the internet. That may be the internet
It's very true.
issue.
It's closed.
It's closed. Okay. It's been closed.
All right, what's the next board meeting? Is that
421.
April 21?
Yeah.
Just quickly, what is that internet issue you keep referring to?
There was, we were putting together, the company was putting together a web page there to offer promotional sales, and apparently, Commissioner, when the internet page should have never gone up, it should have been under construction. Apparently, we did not list the specific number of beers that you would get in the package, and the only thing that was left out with that was just the number 2. You get 2 beers with the package, and we were cited for that. And we immediately, once we learned that there was a violation, we immediately pulled the web page off, shut it down, and we entered a plea of no contest to that because unfortunately we were wrong. So we made a very sincere effort to try and correct these things almost immediately.
Okay, thank you.
All right, we'll see your client and the consultant on the 21st. Thank you.
Thank you. Thank you, Commissioners. Thanks.
Okay. Are there any matters left in Albany?
No, we're all set, thank you.
Okay, thank you. We're going to leave the monitor up, though, so Cindy can register
okay.
the votes. Okay, 775, a proposed advisory for supplier distributor marketing permit.
Good morning, Keith Dano. I believe this is supposed to be put over till the next.
Yes, we have a new draft that was posted to our website, and it's up there, and we, at least if anyone has any comments, they could submit that to us. So we're actually going to adjourn it until the 24th?
21st, right?
Oh, 21st. I was pushing it as far as possible.
You just want me to show up on the wrong day.
So then the next one is 776. It's also a proposed advisory, donations of alcoholic beverages to charitable organizations, and this one is also being carried over.
I believe we received a request from the Bookman Law Firm. They're representing a new client that had interest. It's a non-for-profit. It's a museum. It's a new client, and they were interested in commenting.
It's just to be clear, it wasn't the Buckman Law Firm, as Mr. Kozlow shaking his head.
Oh, no.
Rob Bookman.
Bookman.
Oh, okay. I
Okay.
thought it was.
And there was an additional change that should be made after input from Mr. Danow and the Retailers Alliance regarding the donations by retailers.
Okay. So the 21st as well.
And then we have 783, proposed advisory, and this one is also being held over till the 21st.
Yes. A request for the April 21st.
Okay. 774, proposed advisory tastings.
I believe that there's no one with any comments on that. I think it's just a summary of the law.
Yes. We can actually vote on this. Is the proposed advisory, is this also listed on our website, or you'll post it after?
We'll post it after. It is just as Mr. Danow stated, a restatement of the law intended to aid those applying for licenses and practitioners and how to guide people applying for licenses for what each license offers.
I adopt the advisory. The one concern I had was actually on the previous, the new draft. Oh, I did see it. It's actually posted. I was going back to 775. Wanted to make sure that was on our website. But I did look, and it is.
Okay. Yes.
You had a comment about this current one, 774?
Yes, I believe there is just 2 typos in it that will.
No change before
Yes.
posting? Okay.
Okay, I agree. I adopt.
737, declaratory ruling, Food and Beverage Innovations, LLC.
Keevan Dano for Empire Merchants. I've been asked to oppose this. I oppose this. I can put that correctly, for 4 basic reasons. First of all, I believe that the machine is illegal in New York. I believe it is a machine that will make Jell-O shots in advance of them being ordered, which is under our law on adulteration. We have regulations and laws that say that you have to pour directly from the bottle so that the patron can see the alcoholic beverage that is being used in the product. And
How would this be any different from a blender?
well, with a blender, what happens is you pour the alcohol into the blender in front of the patient at the time the drink is being made. It's illegal to, in New York, to, for instance, make up a bunch of margaritas, leave them in the blender, and then pour them when somebody orders them, or put them into another jar and put them in the refrigerator and pour them when somebody orders them. In this case, what's happening is it appears that you're going to put these machines into the things, make up a tray of Jell-O shots, and then when somebody orders them, you take it out of the tray and you serve it.
So if somebody, sorry to interrupt, but so if somebody were to order a vodka cranberry Jell-O shot, and they took a bottle of vodka, and you can name whatever vodka you wanted, and they poured in front just amount for 1 capsule, and then the capsule came out,
That would be legal.
that would be legal, right?
That would be legal, yes.
So when you say the machine, your belief that the machine is illegal under New York, you're not actually talking about the machine, you're talking about how it may be used in practice.
I'm talking about how the machine is described in the manner of making the products as described in the request for declaratory judgment that was posted on the SLA website and attached to today's agenda.
Because it's counsel's office understanding that this is a machine that is countertop size, that sits out on the bar counter or the back counter of the bar, and that patrons clearly choose which alcoholic product they want and see it being poured into it just as they would a blender, and order the number of Jell-O shots that they want at that time.
I would have to say that I doubt that, but I can't dispute it. The reason I doubt it is because you're talking about now the description is that it takes 10 minutes to make one. So now I'm walking into a bar and I'm asking for something, and you're going to bring it over to me in 10 minutes. And at the same time, they describe it as having the shots in the tray for individual service, and making a tray full for individual service. It is inconsistent with what I read, but I have to agree with counsel, or that if counsel's point is correct, if that's how the machine were used, and also if Commissioner Kim's point is correct, if that's how the machine was used, it would be no different than a blender, and it would be legal. Second thing that I would is about the advertising on the side of this machine. And with regard to that, there is a problem as far as I can see, because if I am sitting there and someone is saying that they're going to, it has Grey Goose on the side of the machine, and then they're making the Jell-O shots with Absolute vodka, then I have a situation in which I'm giving the appearance that I'm selling one product when I'm selling another. So it's either false advertising or false service, and I think that that's a problem too. And
But
because
currently, I'm sorry to interrupt, but currently we have coasters and beer glasses marked with all sorts of labels from different manufacturers, and that gets put out and it's not always matching the product that's in the glass. Is that false advertising? Is
once
that
again,
deception?
the product is poured in front of you at the time, and you see it poured, so you don't have that problem. But when you have something where the machine is going to make them and store them inside the machine, then I have the right to assist. Then it's like the beer tap, where I have the name on the beer tap. If I had the name on a beer tap and I were to take a mug and fill it with from that beer tap, and I don't get the beer that's in that's written on the name of the it's completely different. It's written on the tap. It's completely different than if I put that beer, which I took off of, let's say, a Miller's tap, and put it on a coaster that said I should have been drinking Beck's beer.
So it goes back to your issue of how the machine is used. If it's not used to make things that are to be consumed right then, if it's in mass quantity.
I would say that is so. If I see you pour it in, and by the way, I would like to distinguish in this request, they show you a picture of a Jägermeister machine, and the I can't see what the other machines are, so I can't comment about them. The pictures that came out on the website were not clear, but the Jägermeister machine I recognize. The Jägermeister machine puts bottles of Jägermeister on top of the machine. The patron who sees or orders a Jägermeister would see it coming out of the bottle one shot at a time to come into the beverage that you're talking about, and that's what distinguishes it. Again, you know, I don't know whether this machine is capable of making one cup. You know, as Commissioner Kim suggested that somebody could put in just enough alcohol to make one little cup and then serve that little cup. But it's my impression from reading this that that's not how it works, yeah. that it makes a tray at a time, and and then they describe the tray as for to be sold to consumers, and that's what gives me trouble.
Counsel, when you actually, I went onto the website of one of the particular machines, and they look as if they make almost like a dozen product all at once. Is there a possibility that they could make one at a time? I would think that would defeat the purpose of the 10-minute.
I was under the impression that they can. I've spoken to the applicants here. They are out in Portland, Oregon. I told them that I did not think it was worth the trip from Portland, Oregon to come here today, but hearing Mr. Dana's concerns, it may be worth their trip from Portland, Oregon to come and address these issues, and I would suggest that we adjourn the matter for their response.
And one of the things, even if they come and present, if they have either a diagram or pictures of a machine that actually does administer only one, because all the ones I saw were multiple trays. So if they can demonstrate that in some way, it could be a video that maybe they could send us in advance.
Or bring it along. That'd be great.
We could all have a Jello shot.
Well, you can have a shot. We can't have a shot.
Can we just have the Jello?
What were the other 2 points you had? You said you had 4 points?
Well, there is an idea here that they are going to sell some of the advertising on the machine and then also sell the machine, and I have concerns about whether or not there would be a gift or service because of the issue of how you're going to determine whether or not there's a discount to the retailer on the value of the machine because of the advertising that's done by the supplier.
Actually, that was my biggest concern reading this, was the selling of the ads on the side. You know, I don't know exactly what their business model is, but I'm assuming if it's like the Nespresso coffee capsules, a lot of it is on the selling of the capsules themselves, and then on top of that, they're selling advertisement, which is also a huge revenue stream, I would assume, and based on the manufacturers and distributors putting in the ads, and then that's subsidizing the cost of the machines that the company sells. They'll probably end up giving it away practically to the retailer because they'll make money on the capsules plus the advertising. So
there is that concern.
That indirect benefit and indirect gifting, I would think from the manufacturer to the retailer could be the issue that I saw.
That is of concern because there'd be no way to police that balance. You know, how much you're charging. So those are issues that I thought that should be brought up and addressed by the members in making a decision here.
That's only 3. You have 4.
One
It's
more.
Passover.
Well, it's a holiday. There are four.
We'll come up with the
The
first.
advertising, the adulteration, the question of false advertising, and the question of gift of service. I counted that as four, but.
All right, we'll take it.
All right.
Thank you.
Thank you.
You'll reach out to them and see if the 21st is too soon. We can put it off for the next.
Yes. Over till 4/21.
We'll do 21st for now, and then
I believe
we
those
may
are all
change.
mine, Carrie.
Excuse me?
Those are all the ones I signed up for. Right? Thank you all. Happy holidays.
Okay. 733 to 735, 523 9th Avenue, Inc.
Robert Romano.
Good morning.
Good morning.
You're asking for a reconsideration?
I actually, it was a withdrawal of the original two charges and a plea of no contest to all three.
You're asking
Right,
for,
yes.
to reconsider
Correct.
the penalty that was
Correct.
previously imposed. And your new offer now, including that third proceeding, is $2,500?
Yes, 25,000.
$25,000, thank you.
I'll take 2,500.
Have any questions?
I have discussed this with my client, and they are very aware that any further violation would be met with the strictest penalties.
And this really is the last
I know.
last straw.
And they're aware of that.
Yeah, I'll take the 25,000 with the understanding this really is the last straw.
Because their history
I
is
understand that. I made it very
excessive
clear.
is to really understate it. But I'll grant the reconsideration and I'll accept the $25,000.
Thank you very much.
I agree.
777 and 778, Albany Manor, Inc.
Good morning, Commissioners. Martin Miller, Miller Buscemi.
Good morning.
This was after a hearing in which the charges were not sustained.
But, Mr. Miller, your client is still dead, and there's nobody else on the license now. And so who are you representing? And you have somebody who's unlicensed who's been operating this place for months now at the request of the authority to put the license in safekeeping until the estate can be worked out.
Counsel and
you're-
I have had this discussion before. As of, I believe, a week ago, the Surrogates Court of Kings County finally named the executrix who was in the will. It was filed, but it may be in the P.O. box. Now, I'm saying it may be in the P.O. box. So the executrix of the will has been appointed by the surrogate of Kings County. We had this discussion for about 1 hour before the ALJ as to whether I could represent the corporation. The ALJ ruled that I could represent the corporation. The authority did not want to allow for any adjournments. The ALJ gave...
The authority gave you an adjournment. I gave you an
Let me finish, and you may say whatever you want, because I was there, you were not. 3 times, the ALJ asked the attorney for the authority, do you want an adjournment? And she said no. He says, in that case, let's go forward. I had witnesses. The authority had a piece of paper. The ALJ ruled in favor of the licensee.
I had emails with you from January 13th, and I believe even earlier regarding adjournments in this case, because you
That's right.
told me you were going to, and I granted an adjournment.
One adjournment to
In
the
this
15th.
case-
I asked for another one. You said
Wait,
no.
we already heard you, Mr. Mailer. Continue, counsel.
You were given one adjournment to get the estate straightened out, and it was suggested to you strongly by me that you place this license in safekeeping, as the people that were running this operation were not licensed, and the licensee was dead. You refused. Then it was on for the hearing. You asked for another adjournment, and I said counsel's office would not agree to an adjournment, and suggested again that you place the license in safekeeping. This was all back in January. You're now saying it's only April now. And so for 4 months, when this license should have been in safekeeping, it wasn't.
I disagree with the fact that it should have been safekeeping. I told you that then. This is the only means of livelihood for that family. I told counsel that the grieving widow was asking me to put this off so that they, literally, the day that this tribunal originally decided this matter, that's the day he died. And I asked counsel, and I also explained to counsel that the reality of the Kings County Surrogates Court is that it doesn't happen within a week. Counsel did not want to hear that. She wanted this thing just to go forward. The application for the letter. By the way, I'm not handling the estate, so I was conferring with the estate attorney, and he just said reality is that the Kings County Surrogate does not issue these letters overnight. It takes a long time. It took a while. I'm sorry it took a while. It was very clear that the executrix wanted me to be the attorney for the corporation. We went forward that day. The ALJ had all of this in front of him. He knew all of, and in fact, there were all exhibits within the hearing, and it was the authority that did not want to allow for an adjournment.
No, this was a place that had serious charges pending and a dead licensee.
Okay, and the bottom line here is the charges weren't sustained. So how serious were these charges?
Well, my main issue actually with the ALJ's decision was he comes to a conclusion. He says, I therefore find that patrons were still in the premises after 4:30 and consuming beverages. And he comes to this conclusion for all of the charges. And then in his next paragraph he says, however, I find the evidence presented by the authority fails to establish that the beverages consumed by the patrons were alcoholic beverages.
That's true.
And again, he has the same, all three charge 1, charge 1, charge 2. All three have the same exact conclusion. I know it's true because it's written here. I'm reading it for you, but my issue is that in the evidence that was submitted, it said that the police report said it was observed that numerous persons were consuming alcohol out of bottle and cups inside the licensed premises, end quote. And that's also the same charge that's in all three of the charges. The police reports for all of the charges has that same statement. And so if it were the case where it was just cups, and I get it that nobody checked to see if the cups were alcohol, and if they were holding any alcohol in it, no one tasted it, no one smelled it. But the fact that each of the police officers observed the bottle of alcohol, I would assume that the police officers, when they're consuming alcohol out of bottle, that they know the difference between a bottle of alcohol and a bottle of Coca-Cola or some non-alcoholic beverage. And the ALJ actually concludes in each charge that he does find that the patrons were consuming the beverages. So then I don't understand how that goes down to the final conclusion that the evidence presented fails to establish that the beverages consumed by the patrons were alcoholic beverages. So that's my issue, and so I'm going to vote to send it back for alternate findings.
But may I just?
It's a completely legal. I don't know about. I'm not even addressing your adjournment and whether you have it. This is just from my reading of the hearing.
May I just address that before you make a ruling? Sure. I gave the ALJ at least 5 or 6 cases. He decided to take one of the 6. If you read K and Z is exactly the same. The fact that somebody says a bottle of an alcoholic beverage or a drink of an alcoholic beverage, that is not sufficient to sustain the charge. Couple that with the fact that I had a live witness that actually came on and testified and was held to be credible that they were not consuming alcoholic beverages. Case law is very clear on that as well. When you match a piece of paper against a live witness and the live witness seriously controverts the piece of paper, the courts have consistently held that is no violation. So it was not. The decision was absolutely correct on the law. You're right. I mean, this is just a collateral issue that shouldn't have come up in the first place. The real issue was whether there was substantial evidence to sustain the charge. And merely stating on a piece of paper that there was a beverage consumed on the premises without being specific.
Alcoholic beverage.
Again, an alcoholic, the case that...
And the ALJ does credit the portions of the police action report. He says, I credit the portions of the police action report indicating that patrons were drinking beverages.
But it's not sufficient to sustain the charge. And the cases I cited, including K and Z, are right on point for that. So what are we talking about here?
So you're saying if an officer goes in and observes alcohol being drunk out of a cup or an alcoholic bottle, then they come and file this police report, that alone in itself is not enough.
That's absolutely correct.
So you're telling me that the case law requires what else beyond that?
Specificity, that's the term.
What do you mean specificity?
Budweiser beer.
How could they know if it's Budweiser beer if it's out of a cup? I mean, beer is...
Forget about the cup. No,
Oh, so you're talking about the bottle, you're talking about the bottle, the person has to say that is this brand of beer?
That's what, read K and Z, that's what it says exactly. Read the other cases that I cited that were part of the decision.
'Cause I'm just concerned that in all of the occurrences the same. I warrant the officer, the actual exhibit specifying that there were bottles of alcohol being consumed. Specifically, every time the ALJ mentioned the consuming bottles and cups of alcohol.
That's conclusory in nature.
I understand that. We obviously disagree.
But I mean, but it's not a question of disagreeing, it's what the case law says.
I know.
But I mean,
You're
this is the
disagreeing.
Appellate Division in
You're
Court of
disagreeing
Appeal.
with the fact that we want to send this for alternate findings. You disagree, correct?
If that's what you're going to do, that's what you're going to do. It's not a question of disagreeing, but it's contrary to
All
the
right.
law.
I'll vote to send it back.
I agree. And I will go study the law some more.
Would you like me, you know what, for the next one, I think I'll put in, I mean, I submitted it to the ALJ, it should be part of the record, but I'll do it again. I'll show you what.
Okay.
the law-
Sure.
Thank you.
Thank you.
All right, I got one.
710 and 727, MD3 Inc.
But one other thing, when
Was
that.
it 710?
Can I just, one point of clarity here. There is an application, it's probably in the P.O. box, but it's pending. That will go forward, right? So that this issue about whether.
You said application for?
To name the executrix, to be, to.
Oh, for the previous case?
Yes, yeah.
Okay.
Yes.
Okay, thank you.
Okay, now 710.
Yes.
Do you want to be heard?
Well, it's just, the only thing I'd like to say on this is that the license was not renewed, and that whatever penalty you want to mete out, just please do not go beyond the cancellation. I mean, ideally, I think
Okay.
a
That's what I
monetary.
had to cancel.
All right.
Same here.
I'll dismiss the charges in first proceeding 2 and 8. Counsel asked to withdraw 11. Dismiss charge 1 and 5 in the second proceeding. And for the remainder, cancel and bond.
That's
I
fair.
agree.
Thank you.
745 Town Liquor Store Inc.
Good morning.
Morning.
Koppelman, counsel to Schloss and Schloss. We believe that the public convenience and advantage are clear in this case to allow my client to open a small liquor store in the village of Haverstraw. The 3 locations, 2 in West Haverstraw, 1 in Haverstraw, are up on 9W. I don't know if you know Haverstraw at all.
Mr. Koppelman, we did receive protests from 2 of the closest. Let me just see, anyone in opposition and wants to be heard on this application? Okay. I see that there's, the closest store is about 2/10 of a mile away.
A little more than 1,000 feet, about 1,056 feet.
That's about, but this area is pretty much city blocks. They have about, what, 5 to 6 blocks away from this location, and they're on a different street. So I'm familiar where the area is. Do you have any questions? No? All right, I'm ready to vote. I'll approve.
I approve.
Thank you. Happy
Good luck.
holidays.
Good luck.
742 Farmingdale Wines and Liquor Corp. I believe it's opposition that has signed in.
Oh, so the applicant
Applicant
is
signed
not
it.
here? Okay.
Yeah.
Did the opposition sign in on Farmingdale Wines and Liquor? Oh, step up, please. State your name for the record.
Yupyeong Choi.
Do you have a store in the
Yes.
vicinity? Can you tell me where that store, give me your address and the name of your store.
918 Main Street, Farmingdale.
Okay.
It's about like a half miles away by the car.
Half mile? We have 1.6 miles away.
1.6?
Yes.
But it's by the car. I mean, it's a residential area, and the population doesn't increase anything. It's the same. I've been there 10 years, and my grocery sales have dropped, and other stores open about 1.5 miles away, Farmingdale Village, about 1.5 years ago.
Okay. And you're on the same street. You're on Main Street, correct?
Yes.
Okay. Okay, thank you. Anyone else?
Morning, Commissioner Green, Commissioner Kemp,
They should have been.
members of the board, Robert Bernardini, owner of Uber Wine and Spirits in Farmingdale.
Good morning.
Good morning.
Excuse me, I'm sorry. The proposed application that we're discussing now is literally less than a block away from my store. It's less than 500 feet from my store.
You're at 309 Main?
I'm at 309 Main Street, that's correct?
Yeah, we have you about 1/10 of a mile.
I've found that I mean no disrespect by this, the lamp system that does some of the measurements is sometimes off. I've used Google Maps and it tends to.
We are not using.
Okay, I'm sorry. I apologize.
Using driving directions. For
This is my first, well, my second foray here. The first was 1.5 years ago to get my original license. In addition to my being a new store, I've only been in business for under 1.5 years now. I know that the village is opposed to another package store in the village. I know that the mayor had called, had made numerous phone calls to, I guess it's Investigator Center, in opposition to the new package store.
Do we have anything from the mayor?
I don't think it was submitted in writing. I know he called yesterday, I know he called on Friday, and I believe he called 3 weeks ago. Told me yesterday that he called again and
The
left a
mayor
message.
told you?
Yes.
You may want to, if you have an open line of communication, maybe next time you could ask him to write to us directly, because otherwise, if we don't have it on record, it's harder to verify that.
I will do that then. In addition to the mayor's opposition and the village's opposition in and of itself, this proposed location is directly across the street from a preschool. It's less than 50 feet away. I submitted photographs of that, and I have them here as well. If
200-foot law
doesn't apply to
Right to a
preschools.
preschool.
it doesn't,
No.
okay? So you guess you don't want the picture?
Oh, is it this?
Yes,
I already
there's
have it, yeah, I already have it.
And, you know, quite honestly, I'm all for open marketplace and fair business practices. Yesterday is a perfect example. It's a small village. There's not a lot of population. There's a fair number of stores, some larger stores like Stu Leonard's and Bottle Values. Competition is fairly tight in the area. The population has not increased. Yesterday, I did $612 in business, which, quite honestly, according to my computer, came out to $115 in profit, or $11.50 an hour that I made, prior to the $50 a day that it cost me, the $150 a day that it cost me to cover rent, electric, and all that. I'm not looking to be a millionaire by owning a business. I'm just looking to run a fair business. And by opening another store 500 feet away from me is
What's the mix of your wine and liquor sales?
I'm about 70% wine, roughly. And it's off the top of my head.
All right.
I'm ready to
Ready to
vote.
vote.
Yeah, they had noted, the applicant had noticed that this was on. My concern is that this would be the third store to be licensed on Main Street, and that's within a mile, 1.6 miles. And I think that's a saturation issue, especially based on the gross sales that were reported, so I deny the
I
application.
mean, the only reason why I would even consider approving it is if the applicant were here to explain why their model would be any different than all the other stores that are properly servicing the area, so I also agree to deny. Thank you.
Thank you very much.
751 Hilaria Riva Restaurant Corp.
Good morning. My name is Maria. I'm not a lawyer. I just the accountant, and I want to have some translation.
Can you state your name for the record as well?
Esteban Ponce.
Yeah, I had a question. I understood that the location was closing at 9 p.m. because those are the hours specified on the menu that you submitted to us. But on your application, you said you were going to be there till 3 a.m. So what are your proposed hours?
Yeah, he said that if he get the license, he will be open on the 11th.
Till 11 p.m. every day?
Yes.
Well, I see, I believe we had a letter from the community board.
They approved.
They approved the application, I see. And this is only a wine. This is going to be a restaurant wine. I saw the menu. You're serving food the entire time you're open.
Yes.
Is he verifying that?
Yeah, he said yes.
So we'll have it on the license, 11 p.m. closing?
Yes.
Closing,
Okay.
yes.
All
All
right.
right, I'm ready. I approve.
I approve. Good luck.
Good luck.
$743 Yolanda Roberts. I believe it's opposition to pending.
743?
743, yes.
Good morning, I'm Yolanda Roberts, the applicant.
Good morning.
Good morning.
You said opposition signed in?
Yeah, I
Do we have
think
opposition? Could we, Ms. Roberts, we'll hear from the opposition first, please. State your name and address, please.
Good morning. My name is Dong Shu Chen. I'm the owner of Wine Obsession, located in 469 Park Avenue, Lindenhurst.
Okay.
We got our license like over a year ago, and we're still at building phase. And inside the shopping center, there's still many vacant space in there, and we still try to build up more clientele in there. And based what I did a research on the Google Map, the driving distance between my store to the application store is 0.9 miles, which is probably take 2 minutes driving to the new application store. And between that, there's another store. I'm not sure if it's here or not. Between that, there's another store. If this license gets approved, so you would have 3 stores within a mile. And basis on the U.S. Census Bureau,
we actually have 4 stores within a mile.
Yeah, so basis on the U.S. Census Bureau, the difference between the population in 2010 and 2013 is only 50. So the area is really not growing. And another main concern that I have with the location of the store is that it's a standalone building on Montauk Highway, and they don't offer any parking space, and there's no street parking, and the limit speed of the Montauk Highway is 40 miles an hour. If somebody decides to double park and run in, get something, it will cause a lot of accident, and this kind of reduces the public safety. And I don't think the store offers any convenience or advantage with other store that has.
Okay, thank
All
you. Anyone else in opposition? Okay, you can step up. I definitely addressed some of the issues that was raised by the opposition. Specifically, this would be the 3rd store, I believe, on Montauk, so, and your parking issue.
The parking issue, you can park around the corner, and I would place a sign that says parking around the corner. They can go into, around the corner, and there's a
Is it a
parking lot
parking
there.
lot?
Yes.
How many spaces?
I didn't count how many spaces. It looks like more than 10.
Is it sharing it with other commercial
Yes.
businesses?
Yes, but, well, when we're sharing, it's like maybe 30.
Okay. And just on the issue that this would be the third store on Montauk, why would this area need one, especially being, we didn't have that many of gross sales submitted. Some of these stores existed already. The licenses changed hands. So based on the limited information, how does this area warrant another store on this highway?
Well, what I'm looking to do is I want to open up a liquor boutique. I want to be more customer-friendly. I want to inform the customers of what liquors and mixers would go with foods. I also want to have an ongoing TV on the mixology channel, you know, and I want to sell other items that would go with their liquor enhancement.
Like what?
Wine glasses, flasks, whatever else I can be allowed to sell in there.
Have you considered other locations?
I looked around. I didn't see anything that was available. I invest a lot of money in this location. It's also been vacant for a number of years, and the landlord would really like this location to be rented.
My concern is, like I said before, what are you bringing to that area that isn't already provided by the other two stores, specifically on the highway, and then the other two stores in the area that's all within a mile?
I know Brothers do not offer wine tasting. The limited wine selection that I will have, I would like to offer wine tastings, and like I said, it would be more geared toward the customers.
Do you have wine tasting?
Yes, there's grand wine tasting coming up on May 9th.
Okay, thank you. All right, anything else?
No.
Okay. Ready to vote?
Yeah.
Anything? Yeah, I'm going to deny the application because there's 4 stores within a mile, and there's 2 on the same Montauk Highway.
Well, Montauk Highway is
Understandable, but even the closest one to you is almost a half a mile away, but everyone's driving there. So it's not as if they're going to travel, 10, 15 minutes to get between stores. The 3 this would be the third one located on the highway, and you can get within a minute to the 2 existing. Okay. So it's nothing that you're offering that isn't available there. So I think if you find another location, we'll take that under consideration.
Okay.
But this application, I'm going to deny.
And in addition to the 4 stores, I mean, it's almost 12,000 square feet. Those 4 stores represent, and so for the same reasons I deny. But I think if you look for another location, we'd consider that.
Okay.
Thank you.
Thank you.
$747 R&T Corner Store Corp.
Good morning.
Good morning.
Good morning.
My name is Ahmed Awad, and I currently own R&T Corner Store.
Okay.
Okay, can you tell me, do you have any relations with the previous owner, Ali A. Awad?
Yes, that's my father.
It's your father?
Yes.
And you are, it says here 200 shares, but does that 200 shares represent 100% ownership?
Yes.
So your father used to own the same location, and then he's just handing it to you now?
Right.
Do you know about the history, the adverse history, the sales to minors
Yes.
previously?
Well, I worked there from 2010 to 13.
So you were involved in both of these sales to minors on August 15, 2011 and June 17, 2011?
No, I wasn't involved in. One of them I was there. The second one I wasn't not there.
And so what would you do differently to prevent this from happening?
Well, I would I would be more cautious, and
I mean, you have to understand that, the sales to minors is a very serious charge. We take it very seriously. The first violation. We understand that sometimes you don't have a system in place, but we hope that after the first violation, you would take steps to prevent it in the future. The second violation, 2 months later,
Right.
that's not showing much effort to do anything differently. And then when you get to the third or fourth violation, you're really entering the zone of having your license canceled or revoked.
Yes, I do understand that. And like I said, I would be more cautious now. And as you can see, that business has been open for over 10 years, and that was the only issue we had.
But that's my concern, is that it's happened more recently. And if you're telling me you started working in 2010, then I'm thinking that when your father was there, he was a lot more vigilant, and now that you're there, we're starting to see these sales to minor violations.
Right, but he's also there with me. He's also working with me, so it's almost like I'm having the same help that we had there.
What are the hours of the store? When does it close?
6 a.m. to 12 midnight.
And you're going to be there at least during the late evening hours?
Most hours. Try to be there,
And can you do anything more than just being a little bit more vigilant? Is there a system you could put into place? Is it just you and your father? Do you have any employees?
Yeah, no, I have also my older brother. He's been there for a long period of time.
Sure.
And it's a family business, really.
Right.
And so I can...
From a business perspective, I understand. After being in business for 12 years, you think, well, yeah, 1 or 2 sales to minors, it happened to us, so we'll just be more careful.
Right.
From the state's perspective and from our agency's perspective, each one of these is a very serious charge. And so I'm really trying to impress upon you that when you're taking over, this continuation, this history will follow you.
Mm-hmm.
It's not like you get to start from a clean slate because you were involved in the business since 2010.
Yes, so
Am I clear on that?
Yes.
Okay.
Yeah. All right. Definitely, you know how costly it is if you have violations, specifically underage.
Right.
Your father obviously suffered 2 penalties, and it impacts on your ability to supervise this place. So do you want an ID scanner? Would that be a...
Yeah, I was leaning towards that. I mean, more for your sake.
Right.
Because
I know the community also has, they do training.
ATAP?
Yeah, what it's called, I'm not sure. And I guess we can maybe try to, go to those types of...
It's really for your own benefit.
I understand,
at this point.
I do understand that, I know.
It's because there's 2 in the past few...
One of them, I believe, was part of the sting operation they had.
Right.
And
but that's what sting operations are for, to catch people.
Exactly, I understand that. And like I said, it was just, you're busy and you...
I mean...
So that's not, I know that's not...
Yeah, ATAP, so...
Okay.
Yeah.
Do the ATAP, all the employees, everybody who's working there, do the ATAP, because it really will make you a little more conscious of your responsibility and how to, police this, because this place is obviously a location that underage seems to get served.
Right.
So you have to be vigilant. I would approve it. I would hope that going forward you would be at least be cautious.
Yeah, and so you and your brother, I would require you guys to take the ATAP course.
Okay.
But I'll approve it based on that. Okay?
All right. Thank you.
Thank you.
I do have one more question.
Sure.
In regards to the other 2, for the other corporation that had the two fines, does that go towards this store now, or like?
No, you'll have a clean record. You'll have a clean record.
Right.
But I'll remember that you came and you said...
I'll remember. You're on videotape. This is recorded forever and ever.
Yes. So I will look it up. I know the area well. Well, you're near the cemetery.
Right.
So it's a residential area, and I know you get a lot of kids there in the afternoon. So
Yes.
it's definitely enticing because now you have the seating.
right.
So just be careful. And like I
See her
said,
there, make sure you card her.
all right, good
guys.
luck.
Thank you very much.
I actually drove by
Oh, you did?
to take a look because it didn't look like that years ago, so that's why.
726, Layla B and E Incorporated.
Morning. I don't have much
Good morning.
voice, so I'm going to rely on what I wrote.
Can you give your appearance, please?
Warren Pizetsky and Bookman for the licensing.
Did you find it?
Sorry, what was it?
726. 726.
Yeah, I'm good. 7266666. It's coming. There it is. Okay.
Part of it,
Yep.
right? For council. Now, council, did you, read in the decision
Yes.
that this location is not exclusively used as a synagogue?
No, what the issue is.
I know they were licensed when there was a synagogue, and they did not make us aware that there was a synagogue that was within 200 feet from 2010.
Currently, today, it is still a question of whether it's exclusively used or not. It's my understanding, based upon the relationship with these owners, there is now some company, I've spoken to the president of the synagogue. I think it was Pinkov and Associates is the name of some company. He doesn't know what it is, but they now let them receive packages there for mailing. That Pinkov and Associates wanted to then make a donation to the synagogue in order to have these packages received there, and the president of the synagogue said, no, we don't want your money on that. No one at the synagogue could tell us what Pinkov and Associates was. I believe they may be members of the synagogue. This synagogue has been there well before I was born. Prior to my birth, it was the Hillcrest Jewish Center. Before that, it has always been a synagogue. It has undergone extensive renovations. It has been undergone renovations for probably the past dozen years or so. Actually, even more than that. But today, we do not know whether this Pinkov and Associates, what it is, if it's anything more than receiving packages there. And we've had mixed experiences dealing with the synagogue and outreach from the community members to the community board about this. The community board received several calls or letters from other people from the congregation or even from the neighboring
That's not in
synagogue,
the record.
Hillcrest Synagogue. I'm answering the commissioner's question, Mr. Pizetsky. People who had concerns because the owners of the hookah lounge, I believe, are members of the congregation and what they could do. And so it was very mixed dealing with the community on what we would hear about what was going on, because everyone seemed to have some interest in these operators.
Okay, do you recommend that we hold this over, because I'm not sure if we
I
have
recommended that
the
this be read.
exclusivity of the church. I mean, because this license should be canceled if it is actually within 200 feet of a synagogue that's exclusively used.
This license should be revoked because at the time of the application, when it was applied for, this license should have never been issued as an OP license because it was a false material statement on the application that it was. And still to this day, it's the position of counsel's office that this is exclusively used as a synagogue. And it would have to be a whole new application for an RW if they wanted an RW or an OP license. This license, I believe, should be revoked because of this false material statement.
Mr. Pizetsky?
Yes. You just received a lot of information that is not part of the record. You're supposed to be deciding this case on the record and legal argument.
My
I
issue
understand.
on the record was that it wasn't clear if the circumstances have changed other than
I'd like to
this
respond
should
to
not
that,
have been. But wait.
yeah.
This had, originally when I read the decision, it specified that this synagogue existed when your client was licensed.
Clearly it did.
And it even admitted for the 3.5 years up from 2010 to now, actually it's been 5, they've been licensed and still within 200 feet of a synagogue. So just tell me how that has changed.
Let's fast forward it. What is in the record as opposed to what you've heard that is not in the record and by the way, We're only talking about the future because the licensee has recently sold the lease. I don't know if they're operating for this short period of time or not. So we're only talking about going forward. What is clear from the record, and that's why you should hear the record and not from an advocate, really, is that the Pinkershaw Associates, if you look at the record, is a law firm. It is very clear. There was no possibility of missing that. Number two, it is also very clear from the record that the licensees that are there now are not members of the congregation, regardless of what you've heard. The only testimony in this case going forward, other than SLA personnel, was from a member of the congregation who is not affiliated in any way with the licensee. He was very clear that Pinkershaw and Associates is a law firm. He was also very clear that they occupy space in the building. He was also very clear, well, he didn't have to be clear because he's the one that placed in evidence, is the document that was placed in evidence that Pinkershaw Associates operates under is a lease. Any lawyer looking at it would see it says lease. And so the only question going forward, I might otherwise advocate for our position at the hearing, that the current licensee, and for the legal position, that since the synagogue was closed during the entire application process and thereafter, during the entire period that the application was pending, up to and including a period of time after it was issued, I might otherwise advocate for that position legally.
But even on the application originally, it did not specify.
Well, also, again, I don't want to get to that because it did not give off the appearance of being a synagogue. But I don't even want to get to that. They're out anyway. There's nothing here to save them.
The charge is at the time
I
that
understand
they
that.
apply.
They're gone no matter
So everything
what.
that you're discussing is irrelevant. The time is at the charge, and that synagogue has been under renovation since its inception.
I
They
might
have not
argue, I am
completed their
not
renovations.
arguing for the legal position that they should keep their license because they're out anyway. There's no point to it. You can cancel the license. It's not going to change anything. The only point left is whether the entity, which is, as I understand it, is a third-party transaction. There's no business relationship with the entity that purchased the lease, would like to know, based on the fact that the document and evidence was clearly a lease, it was clearly a law firm that Pinkershaw Associates is, and clearly from the testimony in the case, Pinkershaw and Associates occupies actual space in the building. So the only question remaining is whether the purchaser of the lease.
Are you representing the new
I'm not, but they asked.
Why is that the question before us? That's no question before us.
Well,
the only reason why is because you're representing the previous person so that they can financially benefit from doing something illegal by setting up a business. Oh, they already sold it. Well, we'll see what happens when the new person realizes that they sold a business that shouldn't have been there in the first place.
The new person actually just called me and said, you know, can you, as part of this process, see if there can be a determination, regardless of what was 5 years ago, that
But that's not before us, so we're not going to make a determination. No, it kind of is in your mind and in the new person's mind, but it's not before the record. The record is before me is whether it was licensed within 200 feet of a church or school on 3/9/2010, and the false material statement on 3/9/2010. And I believe that both of those charges are sustained, and we will impose a fine.
Before we impose, I see the prosecutor, Ms. Chapman is here. Can I hear from the prosecutor?
Sure.
Well, it's true that the synagogue was under renovation. The synagogue was established in 1982. The sole witness for the licensee was a member of the synagogue for 24 years. So if there is any question of whether this was a synagogue, the sole witness had been a member of the services there for 24 years.
I'm sorry, but just doing the math, 1982, were they 24 years from 1982 to 2006, or were they members between 2000, at the time of the charge, 2010? Because if they were just members 24 years from 1982 and they would stop being members at 2006, they wouldn't have information as what was going on necessarily in 2010.
He was continuing because he's still a member there.
He's still a member, so the 24 years covers the period of 2010.
In any event, when the licensee answered no, it's apparent that the licensee didn't do any research as to what was existing right across the street from them. They didn't inquire to the Department of Buildings. They didn't inquire as to the landlord of the premises that they were occupying. What is next door? It was 162 feet, I believe, measured by investigator Jamie Marroquin, who's in the Enforcement Bureau. The licensee did not place any testimony in the hearing about what they did or did not do to determine why they answered no. Now, as far as this lease, which was only for a year of 2014, while the lease may be legal, there was no testimony at the hearing that such enterprise was going on in the premises, that there was a law firm. There was no sign on the exterior of the synagogue saying there's a law firm here. There was no sign on the interior that there was a law firm here. That also was testified to by the licensee's sole witness, who was a member of the congregation. He stated that he knew there was an office in the basement, but he doesn't go there because it's not part of the synagogue, not part of the services. So there was no testimony at all by the licensee in the hearing about what was going on or what was not going on by this so-called law firm. The lease may have been legal, but if the actions for which the lease, the contract is issued for, is not going on, and there was no testimony by the licensee, so that's completely irrelevant, despite the fact that this was 2014 and not 2010 when they went in. The only testimony the licensee presented was the member of the congregation. Even though both licensees were present at all hearings, therefore the authority wasn't questioning either one of them, and the only questions were to this 24-year member of the congregation there. So, I mean, I did research. I looked up on Department of Buildings website. I spoke with the community board. I spoke with neighbors. I spoke with other stores on the block. I actually went there myself and looked. And, I mean, there were several methods the licensee, Lila, could have taken to find out what was right across the street from them. But they chose not to, or there was no testimony about any of that. Just the answer was no.
Okay, thank you. So, Mr. Przetsky, you said that your client is no longer
In possession.
in possession. Okay, so I'm ready to vote. The charges were sustained, cancel and bond.
Charges are sustained, and I would actually revoke and bond for the false material statement.
All right, I'll revoke. Thank you. What's the next?
709 Dagda Corp.
Charges not sustained, dismiss.
Dismiss.
Thank you.
Thank you.
780 61 Woodside Corp. Commissioners, 780. It's an over from the last board meeting. I had been corresponding with Pat O'Brien from the Community Board. The Chairman Rosen had wanted us to try to see if we can get more information to the opposition. Pat thought that something was sent to me within, late last week. I have not received anything further from him, so I don't know if you want to give him additional time.
I would like to, because I needed more than just that they opposed the application. Are you the licensee?
Yes,
Can you
hi,
put your name on the record?
Dennis Machopoulos for 61 Woodside Court.
Okay. Because the community board just opposed and we wanted them to elaborate. So I'll give them an opportunity to hear from them. You don't know.
But is this your second? Were you here last time as well?
Absolutely.
No.
My brother was. Me and my brother.
Because we asked them to.
We have community board opposition, and I don't have the details to their opposition yet. So that we're going to.
Do you know of the opposition? Do you know what they are
don't.
opposing?
I don't. I'm basically a diner, coffee shop that stays extended 24 hours.
Okay.
The liquor license currently is till 12 on the weekdays, 1 on the weekends. I do have a big clientele that gets out of work late because I'm on the wall of the Long Island Railroad and the 7 train. So I have a lot of customers that wait for the train. They wait for the times, especially on the late night hours. They get out of work late. So they come down 1, 2 in the morning and have a beer. Now, because of that because I have that cutoff point, I'm doing deliveries to bars that sell zero food in the area. They sell nothing but alcohol. Food delivery. You meant food delivery. He should thought you meant alcohol delivery to bars. And I'm delivering food to the bars because they can't stay with me. And all they want to do is they just want to have a drink.
Have you reached out to the community board at all?
I don't know what the opposition is.
You might want to reach out to them and start some communication with them. Maybe you can alleviate any concerns.
That's another.
Yeah, I just didn't know they had any concerns.
Yeah.
So that's why, up to date, I knew that we had a hearing today.
Right.
I figured that if there was any oppositions, that I would have received them
we
to
don't
this meeting. But, yeah, I sold bagels and bacon. I don't know. Further than that, it's...
Well, we're going to hold it over because I want to hear back from the community board. In the interim, try to reach out to them to kind of get ahead of it. If they have any oppositions, maybe you can come to some middle ground or some agreement. If they have issues that, you're willing to negotiate with them on. Try to reach out to them between now and the next board meeting, which will be the 21st.
Have you had any conversations with them? No. Nothing? Not within the new, the application, they just extend the hours? Nothing.
We had not heard from them at all, and I happened to meet with Pat O'Brien from that community board in the past, so I had emailed just wanting his position. And
Yeah, I just think by next board meeting, if the community board hasn't come back, then we can't, it's unfair to the applicant to keep pushing this back as well. So. All right,
so the 21st, thanks for coming in.
Thank you.
779 Maya Riviera, New York City Court. Donald.
Hi, Alex Medina.
I'm sorry, can you state your name again?
Alex Medina.
See, so I think you had a prior license revoked, is that correct?
No.
No?
No.
He was denied due to character and fitness. That was back in '07.
But you were denied because you had a prior.
2009.
I thought you would, I gotta look, that's what my notes say. Because there was an issue of having misstated to the SLA about permits and method of operation. Does that ring a bell?
No.
Okay.
Was that 2009?
Yeah, they were disapproved.
This prior license was revoked and the applicant principal has that too?
Yeah, he wasn't the prior
Oh,
licensee.
he wasn't the prior licensee.
He's had 2 disapproved applications based on character and fitness.
Right.
The prior licensee was a different entity.
And the character and fitness issues were related to... What was his character and fitness reasons for denial in the 2 previous?
They are attached. attached. They should be attached there.
That's what I have in my
We
notes.
have the first one.
Right, because he hadn't submitted the required documents, right?
Yeah, there was one where he, excuse me.
It was the permits and method of operation.
The Newburgh license?
The Golden Q Billiards Lounge,
Yes, he held that license.
and there's a current revocation proceeding pending at this location.
1178414. I'll see if it's still going on. No, it looks like since then it's been, oh no,
What happened to it?
sorry.
Where's the CNC on the Golden, the Yonkers location?
So you currently have Golden Q Billiards license, right?
No, I don't. I lost the place. I lost the business.
It's an expired license now. So that information is old.
This is old.
That disapproval is, so that means he did have that license.
Did have it, and it was
Yeah.
expired, and it wasn't renewed, or it was revoked?
It wasn't renewed.
It was expired.
Expired,
Yeah.
okay.
Yeah, it was a $3,000 penalty that they had paid for one case.
Yeah, I think the issue there was during the spring, summer, and fall of 2009, you rented out the premises for private parties, correct?
Yeah.
And then they were allowed to BYOB, bring your own wine and beer?
Yeah.
And you said you had temporary beer and wine permits for those, for them to be able to do so. But when the SLA investigators asked you to submit those beer and wine permits, you never did.
Yeah, the thing is that I had lost my car and the paperwork was in the car.
But did we ever issue?
It says it was applied for but had been denied.
Had been denied.
I
So
think
you-
it was just one time.
But you never actually received the permits, you only applied for them.
Right.
Okay. So you know it's a violation to do what you did without actually having approval of a permit.
I never had the parties in the business. I never got to that point because
Spring, summer, and fall of 2009, you never rented out the premises for private parties?
No. That's what I wanted to do, but
That's what you wanted to do, but you actually never did it.
no.
Well, that's not what the investigator said.
That's not what the investigator's saying. So you never rented the place out for people to throw parties where they could bring?
No.
But you just said they could bring, they brought their own wine and beer.
No, that's what I wanted to apply.
That's what you
for,
wanted
yeah.
to apply for, but you actually never rented the place out that anyone did that.
No, that's why I lost the place because I couldn't end up with rent.
He has a current license, right? Westchester?
So, hold on.
Do you have a current license?
With my sister, but we also lost the business in Yonkers. It's M&M Restaurants, LLC.
And you lost that due to?
We lost it because the landlord was, I couldn't go back, I couldn't delay a rent or two because he was, he wanted rent on time, so I just couldn't afford it, so we just let it go.
You don't have the license. We're still showing it as an active license. You need to surrender that license.
We couldn't get permission to go back in the premises anymore because I owed the landlord two months rent, so that's why.
Okay, but you can go online and there's a form that you can fill out
Okay.
to effectively surrender your license. It's
Oh,
called a
okay.
petition for surrender, so you need to do that.
Okay.
So now you want a place that holds 1,200 people?
No. It's 100 and,
How many?
150.
What's this, a submitted spouse question? It's very confusing.
Yeah, it says 150 on the establishment questionnaire.
150. What is it? Over here it says 1,200 people. 1,200?
That's the
Yeah,
list of
that's the-
people for the other.
Yeah, that's the
Previous one?
Yeah.
This was for the one in Orange County?
Oh, I see.
Yeah, this
Those are
one
the
that he's
ones.
applying
so
for
now
is
this
in
is
the-
different.
So when did you close the one in Yonkers?
I think it's like about a year ago. Six,
A
8
year
months.
ago?
No, because when we renewed it, we were only working for 2 or 3 months more, and then we couldn't make we couldn't pay the rent no more, so we just.
Were there any violations at that location?
I will tell you. For the M&M, failure to comply unlicensed cabaret, and failure to comply occupancy in 2010, nothing after that.
What concerns me is that you've had a couple of licenses. It seems like you're fuddling through and not sure what your obligation is. Right now, you're looking at a restaurant wine that's open until, what's the hours of operation you're planning for?
I wanted to open from 12 to 2 o'clock in the morning.
And this isn't you're going to be a restaurant?
Yeah.
What are you offering? Is there a menu attached? I didn't see.
I'm pretty much wanted to offer Mexican food.
I didn't see a menu.
There is a menu. Hard to read, but it is there. It's Mexican. Quesadillas, burritos, tacos.
Oh, yeah, those are breakfast. But there's a breakfast menu. You said you're opening from 1 p.m.?
Well, I was thinking of opening in the morning, but I'm not sure if I could make it, so I was just planning maybe lunch and dinner.
You want to operate a place that, till 2 o'clock with light food till 2 in the morning, and this place was revoked. They had a lot going on here, at least with disorderly premise, underage sales, and their license was revoked. So now you want to come in with pretty much the same type of operation. So convince me why we should license this location under your management.
I believe they were in a restaurant. I wanted to try out a restaurant in this location. I think they had it was more club nighttime. I wanted to open from the day, ending it in the night.
But what you're going to do at 2 a.m.? How many people are coming in for dinner?
What I want to do is, I want to maintain, open a little later because there's nothing around the area that provides food at that time.
All right. I'm really on the fence because one of the issues I have is your prior licensing. You really don't have that good of a licensing history with us. You've been denied based on character and fitness for one application. You have a current license that's outstanding. You should have surrendered it to us. You haven't been operating a location in almost a year, and we have no knowledge to that. We actually see an active license for you. So what I would suggest is if you can present really, I would want to deny the application, but I'll give you an opportunity to come back to us, tell us what your method of operation is.
Okay.
Specify what you're doing. I want to have a copy of a menu, but I think we already have it, so maybe forward that to us at the next board meeting.
Okay.
I want a specific plan. You and your sister are the licensees?
No, just me.
Just you?
Yes.
Okay. I want you to return. I want you to send us a proposal what your method of operation will be.
All right.
Your hours of operation, your food, I already have.
Right.
And supervision. I want to know if you're going to be there the entire time. If you're going to have a manager, I want a personal questionnaire.
Okay.
Okay? So we're going to hold this over.
I'm sorry, do we have a certificate of disposition as well? It said here, if you have previously been approved.
Yes.
We do?
Yes.
But then he also put no for that he hasn't He hasn't reported to the authority all other convicted felonies, misdemeanors.
You scan the fingerprints, right? You
Yeah,
have
we've got,
fingerprints on him.
there's nothing that.
Is that there? Okay, I don't know what you put, no, okay.
Have any requests for when he returns on the 21st?
I just had one other question, actually. Do you have any relationship with Saul Hernandez?
No.
No? What kind of rent were you paying at M&M restaurants?
I was paying $3,500.
So, if you couldn't afford to pay that, I mean, how do you propose to pay $5,000 a month at this new location?
The thing is that the landlord there is giving me a chance to like open and establish the place there because he has the place has been shut down for I think 3 years. So he's giving me an opportunity for me to establish the business and then.
So the previous M&M restaurants, is it a restaurant right now? What's going on with your previous location?
No,
it's just shut down?
Yeah, just shut
Nothing's
down.
going on? And the
Nothing.
license is inside?
Yeah.
Okay. I agree with Commissioner Green's position. 421.
Yep.
Okay. Thank you.
750 Infante Deli Grocery, Inc.
Was it
750.
Hi, good morning.
Emmanuel Infante, Infante Deli Grocery, 92 North Franklin Street, Hampstead.
Do we have anything from the mayor?
No.
No, I do not.
What are the hours of operation?
8 to 11.
Okay. This is not an eat-in, so.
No, it's not eating on
That's
premise.
usually what the mayor
Right.
usually opposes. There was no previous, the location was licensed previously, but I didn't see any adverse history.
There's never been any violations there.
No.
Everything's been.
Did you just buy the business?
I voted from the gentleman that was there for 16 years.
Okay.
Okay.
All right.
I'm ready to vote.
I'm ready.
All right, I approve.
I approve. Good luck.
Thank you. Have a wonderful day.
You too.
Yes, you too.
As far as the 8 taps on, I already did my 8 tap for.
Awesome.
And the 16th, I got my 8 tap for alcohol.
Great. Thank you.
Great. Continue the good history at that location.
Yes.
Hempstead is very up and coming still.
Great.
Just don't have to eat in, you'll be all right. Good luck.
702 Shell's Bistro, LLC.
Andrew Shell, Shell's Bistro, LLC.
2.
When Jackie calls it out, I listen.
Oh, so you ignore me?
I'm kidding. I'm kidding.
The truth comes out.
You were
morning.
unlicensed for 7 days.
Can you put your name on the record?
Sir?
Your name on the record?
Andrew Shell.
Okay. So here for disciplinary, there was 2 charges. Failure to notify unlicensed storage. Are you aware of that?
Yes, I am, and I asked for transcript from the office on February 20th, 2015. So it's more than 30 days, and I'm still waiting for it.
So you want to have a controversion to?
Yes, that's
the
why I was
charges?
asking for a
Okay.
transcript.
Did we have? I don't know. Kim usually
try.
gets those emails.
I'm not sure. Jack, do you know who gets the emails requesting transcripts? Is that
Kim
separate?
Stevens should. Kim Stevens will order the transcripts. And this licensee also has another matter pending, so.
Will that be coming to the board by like the next board meeting?
The hearing notice is
Oh.
for, no, the hearing hasn't been conducted yet. I'm trying to see when the hearing is on, but it's not coming up.
You want to hold this over so we can get in the transcript?
Yeah, we're gonna have to. Would the 21st be enough, or we have to put it over
You can try with the 21st, and we can notify him if she can't get him the transfer.
Okay.
In time, but I'll talk to you if you want.
I would suggest a little
Longer?
Longer? Okay.
just so we don't have to pay more, or doesn't pay more for the transfer.
Okay. All right, what's the next one after?
I read it, I don't remember.
Good?
May 5th, I believe, yeah, May 5th.
Is it?
Okay.
Yep.
All right, we're going to hold this over to May 5th. You'll receive a transcript, and I understand you have another proceeding,
Yes.
so make sure you answer the documents that you receive. Thank you.
Thank you.
We have no other signed-in items.
Oh, wow. Record time.
Are you here?
You want to go forward with the remainder?
Mr. Eber?
Are you just observing today? The new dynamics, you want to see what it's like without Chairman Rosen up here? Studying, analyzing our behavior?
His company is Melissa and Michael Spernick.
Oh.
Welcome. All right, you want to keep going, or you
Yeah.
need a break?
No,
You're
I'm good, yep.
All right.
I know.
You like the new regime, right? And we didn't even email each other, right?
I know.
Okay, 687, Mitiera Food Center.
Revoke.
Revoke.
688,
Offer 5,500, accept.
Accept.
689,
Offer 2,500, accept.
Accept.
690,
Offer 1,000, accept.
Accept.
691,
I have 692. Oh, we're stuck together. Offer 3,500, accept.
Accept.
692,
Offer 1,500, accept.
Accept.
693,
Offer 3,000, accept.
Accept.
694,
Offer 2,500, accept.
Accept.
695,
Offer 2,500, accept.
Accept.
696,
You want to go back?
To 695, and
Sure.
that was about a letter of warning. This was one of those machines where you put the quarter in, and if it pushes all the quarters out.
Oh, yes, that you went on.
Yes.
Okay.
But they get a letter of warning. I don't think
Sure.
people think of that as your traditional gamble.
Oh,
Okay.
okay, not a problem. Letter of warning per council.
696.
I'm feeling good, huh?
Council wants a name stop on Michael LeBoy and his wife, Natalie.
696?
Yeah,
Okay.
Viniero.
All right, I'll revoke.
Revoking
Name
the
stop.
name stop on Michael LeBoy and his wife, Natalie Viniero.
697,
Offer 3,000, accept.
Accept.
698,
Offer 1,500, accept.
Accept.
699,
6,000.
6,000.
700,
Offer 7,500, accept.
Accept.
701,
I know we usually do 3,000. I reduced it to 2 since they've been licensed.
Yeah, I actually had
2,000.
2,500, but I'll do 2. Okay.
703,
Withdraw charges 2 and 4 per council. As to the remainder, what did I have? 2,500.
I agree with the withdrawal charges 2 and 4. I had 3,500.
I'll go up. I'll do the
3,500.
3,500.
704,
Offer 5,500, accept.
Accept.
705,
5,000.
You know, I had 3,000 here because we had issued 2 licenses but made a mistake.
The concern I had is that they've continually had noise. They've already been a nuisance to that community. They've received notices from the town. I think they went to like a town meeting.
Mm-hmm.
So it seems like they're not getting the message.
Yeah, I think their argument was that they had no town noise ordinance, and I know they have been causing a lot of issues, and we also made a mistake on our side. How about 4,000? You want to stick with 5?
No, I'll do the 4,000. I'll come down.
Okay.
Being that they did not have any prior noise violations, but it's just that they took the route of, there was no like DP, stating that the noise was outrageous, but I credited our investigators knowing, that
And I
it
think
was
they're on notice
excessive.
now, and I think future violations will be dealt with accordingly. Thank you.
707,
6,000.
6,000.
708.
I wanted a suspension. I would go lower on the penalty, but I wanted a 7-day suspension and 8,500.
I actually wanted to bring these guys in as well because I wanted to see if because they were claiming that they only sell Corona and Heineken, and one of the charges was that the police officer saw a Modelo beer, and if they can somehow prove that they only sell Corona and Heineken, I thought one of the charges should have been dismissed. And then there was also a discrepancy in charge 2 where the police report said the auxiliary went over and retrieved the beer when it seems like all the beer is behind the counter and locked. So I don't know if they were talking about the same case and if there was some discrepancy there. So I definitely wouldn't go as far as a suspension. I had closer to...
Want to have them in or...
Yeah, I'd like to kind of just hear... Because they had, 2004 to 2016, they had no adverse history, and then all of a sudden, boom.
Yeah,
so I also want to know what changed.
Is this the fish market? Where
It
you
is
go
the
to
fish
Subway?
market, yes.
Yes.
Well, I don't know if it's right by the subway, but it's a fish market.
Yeah, but where you going by your raw.
Yeah. I don't know if it's the raw fish.
Yeah, I pass
This
it
one's
every
on St.
day.
Nicholas.
Yeah, by the C and the E and the...
I think it would be beneficial just to understand what's going on, because for 13 years they had no adverse history, and all of a sudden, boom.
And they're cleaning the subway, the sidewalk every morning. They're very diligent about that.
You want them to bring invoices showing
You
what
want them
products
to
Right.
show
ordered?
what
Yes,
they're-
please.
what they've ordered from the hotel. Okay.
For 21?
711.
2,500.
2,500.
712.
I'll dismiss 1 and 2 as to 3. I have 1,500.
Dismiss 1 and 2, 1,500.
713.
3,000.
3,000.
714.
I have 4,500. These were 2.
I think,
2 under each.
yeah, I think it was, was it 2? The thing was that they immediately rescinded the transaction. I don't know why, but
Well, because he asked for the IDs. They actually served and then said, hey,
And
let me
then
see
let me
your
see it.
IDs.
and then he canceled the transaction, right? So I thought give him some credit for that. So 2,000?
All right. I'll do 2.
Because they do also have 17 years of no
Good
sales to
history.
minors.
No,
yeah.
only 15, 2,000. Right?
Yeah.
You were licensed in 2000.
Yes. Oh, 15 years, sorry.
715.
Offer 5,000, accept.
Except
716.
500.
500 restore
To
bond.
restore bond. Yeah, they're
Okay.
seasonal.
500.
They're seasonal?
No, that's a solicitor. What is it?
Yeah.
Oh, okay.
There is no.
Oh, I thought it
They
was
still don't have
seasonal.
the bond, so they should be canceled.
That's what that's
Oh,
what-
wait, I saw failure for the suspension. Oh, they still don't. Okay.
Yeah,
Okay,
I'd
so-
cancel and then get their attention, so,
Okay, so
yes.
717.
500.
500.
718.
This is the same kind of situation. Cancel.
Cancel.
719.
Offer 5,000, accept.
Accept.
720.
Offer 15 days plus 5,000, accept.
Accept.
721.
3,000.
3,000.
722.
Offer 500, accept.
Accept.
723.
Offer of cancel. I'll accept. There's no bond.
No bond,
They're
okay.
declaring
Accept, cancel.
bankruptcy.
Okay.
There's a bond.
No, there is, but they're declaring bankruptcy, so I'm
We'll just take
gonna
their
do
cancel.
724.
2,500.
2,500.
Excuse me, Commissioners? Yes. Excuse me. Secretary's office received a letter from Mr. Flynn. He is on vacation and is requesting this to be carried over to 421.
Is that 724?
Yep, this is Roebling Liquors.
Yes. Okay.
Thank you.
421. Thank you.
725.
Mr. Bernstein's not appearing?
Yeah, I thought he.
I
He sent
remember
them.
when this license was given and how extensive the application was. I'm surprised he's not appearing after all the statements he made saying
I think
that
we
what his
need them
client
to
would
come
do.
in.
Yes.
Yes, they need to come in.
421?
Oh, yes. Yes, that's, because I was going to do it to save them the trip. All right, 421. Oh, that's quite a few.
728?
Offer of 2,500, accept.
Accept.
729?
Offer of 10,000, accept.
Accept.
730?
4,000.
4,000.
731 and 732?
Sorry, on the 730. They hadn't purchased from a licensed wholesaler since 2008. Our standard offer on a purchase from an unauthorized source can be about 75 for that alone.
But I mean, they have no violations. They've been licensed since 1986. They have actually no adverse.
But for 7 years, they haven't been purchasing from wholesalers. I'm not saying cancel, I just think I had 15,000. 7 years of not purchasing from a wholesaler. Present company excluded from the room. I understand they're in Bladsdale, New York, and they're a small business, but that's been 7 years. And stores that have 1 or 2 bottles from
That's
a
true.
liquor store are paying $3,000, $4,000 for that.
All right, 7 years.
So we'll go up to 5.
5. I'll go up to 7,500.
Okay, 6,500.
All right, 7,000. 6,500. 6,500.
Sold.
Poor Cindy.
Cindy's like, okay. She scratched out a couple of times. Sorry, Cindy.
731 and 732?
They asked for reconsideration. The original offer was for 3,000.
Well, counsel's office actually asked for reconsideration.
Oh, because we denied the CNC. We asked for 5,500, but they're asking us to accept 3,000 now, correct?
Yes, based
Okay.
on a memo written by Mike Amarato.
I'll accept the 3,000.
Accept.
736?
We actually did get a resolution on the litigation in this matter. You may remember this application that it was a Hempstead, and you placed hours of operation on the license that they agreed to. They then filed an Article 78 saying they never agreed to these hours of operation, and they lost the Article 78, and the court said, yes, they did in fact agree to those hours of operation. So the charges are for violating those hours.
In the memo, you asked for it to be returned to counsel's office for what?
That, because the memo was written prior to the decision. If you'd like the hearing, it was a default, so if you'd like the hearing to be done rather than them later on raising it was a default, we're happy to do the hearing, but
But didn't they get a full hearing by going through the Article 78 proceeding?
if that's your argument, yes.
That's my argument. I
I
mean,
would
how
return
much
it
more
to
of a hearing can you get? Want to return to council?
Yeah.
Okay, I'll return to council.
$738?
Offer of 500, accept.
Accept.
$739?
This is a class change from a wine store to full liquor. The closest store is over 11 miles away. I approved.
All right, and I think sorry, was this only 240 square feet? Yes, square footage is only 240 square feet. I approve.
$744?
How could they not show up?
It's entirely bulletproof.
Business. There's no manager for because it's a 2,700 square foot. There's no manager. There's no experience with the liquor store. I question about the
They have
funds.
Protests.
We had protests.
You want to have them come in?
Yeah, I'd like to have them
Let's
come
put
in.
it over to the following, what's that, May 5th?
5-5.
Yeah.
$748.
Sorry, me again. I have a request on this one to carry over.
Okay. Did they request for the next, to April 21st?
Yes, ma'am.
Thank you.
749.
I had a question. I know the actual individual, did they submit documentation with like different spellings of their name?
Oh, yes.
He has like 3 different spellings of his name, right?
Yeah.
And all on like official documents.
I know. It's almost like you want 3 identities to do what?
They've gone a whole year without a license.
They're still in business?
Yep.
There's availing, there's character and fitness issues. I would deny.
Deny. Oh.
$752 and $753.
Offer 5,000, accept.
Accept.
$754.
Offer of cancel and 1,000 bond, accept.
Accept.
$755.
Offer of 5,000, accept.
Accept.
$756.
They offered 4,000 and they did not ask for a reduction, but I was willing to go down
Me
to
too.
2,000.
To 2,000?
Yes.
Yeah, and 2,000, yep.
Okay.
And do we have to, for charge 1 then, do we have to send them a letter of warning about the gambling, or they get it?
No, a letter of warning is always in lieu of.
In lieu of a penalty, you can't do it in combination of,
I think they got your warning.
got it. 2,000.
It's a hefty warning.
$757.
Cancel and bond.
And some bond.
$758.
Offer 4,000, accept.
Accept.
$759.
Offer letter of warning, accept.
Accept.
$760.
It was an offer of 3,000. I actually reduced it to 1,500.
Why is that?
The alteration.
Additional
They
bar,
just-
trading in.
Yeah, it was the patio. I think it was the front patio.
Okay, no adverse history for 7 years. Okay, I agree.
$761.
Offer 3,500, accept.
Except now, why did it take so long when the second bar was approved in December 2013 and it was issued on end of November 2014?
They have to meet the conditions of approval, and sometimes they'll request extensions because the construction isn't complete.
I see. So it wasn't on our part necessarily.
No.
Okay. Accept.
$762.
Offer of cancel and bond, accept.
Accept.
$763.
Offer of revoke and 1,000 bond, accept.
Accept.
$764.
Offer letter of warning, accept.
Accept.
$765.
Offer of cancel and bond, accept.
Now, why is this so harsh on a sale to minor?
No, they made the offer.
Offered it. They must
Wow.
not, they might not have the money.
They just don't want to do it? Okay. So,
$766.
Offer of 1,500 plus 7-day suspension, accept.
accept.
$767. License was
Cancel and
surrendered.
bond.
Cancel and bond.
$768.
Cancel and bond.
Cancel and bond.
$769.
Offer of 10,000, accept.
Accept.
$770.
5,000.
All right, 4,000. And I'd bring in because they're being really unresponsive. Can we bring them in?
Stabbed. That's the only reason.
They're just not even responding to us either.
771?
770?
770.
Crazy Eights Billiards. Yeah, someone got stabbed, but, right, we never, it said undeliverable as addressed.
Yeah, they defaulted.
Didn't
To have
even,
them come in.
but they didn't even get it, so.
If they don't pay the 5,000, then they'll impose the alternate penalty as cancel and bond.
Okay, 5,000.
771, there's a request to adjourn to 421.
Okay.
Okay.
772,
Offer 1,500, accept.
Accept.
773,
I don't think they have no.
Excuse me, Commissioners? Commissioners?
Yeah.
Secretary's office received an email from the attorney on this one. I know it's been carried over. His previous request for carryover was because he couldn't reach his client. He's asking for another month because he can't reach his client.
Another month.
That concerns me.
Yeah,
This is
that concerns me.
absentee. Who's running this place?
I had spoken to Mr. Gardner originally, and he had represented the client on a criminal matter, and therefore then did this. And originally, he stated the client would be appearing here, and he wouldn't. But since we've only been reaching out to him, I don't think the client knows if he hasn't been able to.
Secretary's office sends letters to the principal's home address, the premise, and the attorney on record. And if there's an email, he gets that too.
So the question is, where is the licensee?
Yes, who's running this place? Because one of the concerns was that they have like chips. They're offering chips.
Yeah.
You know?
Yeah, that's what I mean.
Because this was held over, this is going to be the 4th time. And they're operating with no kitchen, no.
So let's count off with the cancel, and then they might come up. They might come in.
All right.
Well,
Counter, cancel, and bond.
if they don't
It's
accept
online.
the counter, that would just get
It
scheduled
goes-
for a hearing.
All right, well, we'll send out notice that, the licensee, I want the licensee to appear. Because
issue
if
a
the
subpoena for
attorney
them to
cannot,
appear.
yes, because if the attorney's not finding them, this place is going, operating, I don't know how.
How else are we going to contact them? We've already sent letters to them twice.
Issue a subpoena, and that's about it.
Okay.
Well, you've been contacting the attorney has contacted you, right, Cindy?
Yes, the emails were from Mr. Gardner.
All right. So this is the last time we're holding this over.
But should we issue the subpoena? Is that?
Yes.
Have we done that yet? I haven't.
We have for, usually in licensing matters, when we wanted, I've done them for when you wanted a reverend from a church to come to find out information about that. You can, he's a licensee. I don't know if it's going to do anything more than Mr.
Track him
Gardner.
down. Yeah, let the attorney track him down. What concerns me, maybe an investigator, yes,
Right.
to see who's there and what's going on in the interim.
So when is this for? 4/21?
Cindy, did
5/5?
he ask for 4/21? Or 5?
No, he asked for a month, so 5/5.
Okay, so 5/5, all right.
Thank you.
Thank
Last
you.
chance.
And enforcement will go out, Jackie? Thanks.
781, that was also held over for licensee to appear.
This one, and we sent notice to appear. It's because they have like a clothing store. And even though we've licensed locations similar.
You have them also.
Yeah, we requested the last board meeting for them to appear. All right, send them one last notice. And tell them this is the last request. This one we could cancel.
Should we do 5/5?
Yep, 5/5.
782,
Oh, the community board, did they make a recommendation?
I don't have anything from them.
I have in the notes against.
Because they had a vote,
Against?
they had the vote the night that this came to the board at the
Yep.
last, I think it was, when was the last
Check.
board
I
meeting?
don't think I have anything. Oh, hold on. I'm wrong.
'cause I
We have
think it was
community
March.
board.
Against,
great.
right?
Does not object.
Does not object?
Does not object.
Wow. Okay. And, because this was to be, the closing hour was 2 a.m., and they didn't object. Did they say anything in there? It says,
Comments from the community in the precinct, heard no negative comments. The owner has agreed in writing to close at 2 a.m. every day of the week as requested. To arrange for a walkthrough by the 34th precinct, and post a good neighbor sign.
You know, their original April 23rd, 2000. This is from 2014, but it's like up on top they say grant, recommending that it granted, and then on the bottom it says it shouldn't grant.
This is from March
Very
25th,
confused.
2015.
But the new one is March 25th, the one you're reading from,
So they're
right?
okay with it?
Okay, all right, I
All right.
grant it,
Grant.
approved.
783A, report of litigation.
Appeal.
Yes,
Thank you.
definitely.
Okay.
Wow. 12:14, 2 hours
We
and
still
14.
got a few more,
Oh.
don't pack up yet.
I don't know where we're at.
Carrie has
I
a
don't-
specific interest for us
Oh, I
to
thought
stick
we were-
around.
783B.
783B,
Oh, right,
I don't
that's
have
that
any
kind of
more.
stuff.
Carrie really wants us to stick around.
Just for a little while. No, 783B and C were over, so this is
No, it's D.
783D.
D, all right.
And now
Just
Jackie, you
Carrie
wanted that
B.
Yes,
withdrawn.
this I'm going to ask to adjourn because I believe we're going to keep Kerry Gould here in New York City.
Oh, good, good,
I will
okay.
speak to Kim tomorrow.
Adjourned.
Okay,
783.
so that's withdrawn, right? You're withdrawing?
I don't want to withdraw until I speak
Wanna
to
hold
Kim
it over?
Capone and
Okay, so you
undo
wanna
any
hold
of
it
her
over.
hard work.
Okay,
right?
hold on.
Adjourned.
All right.
I'm sorry, can I have clarification, counsel? Do you want this held over without a date?
Yes.
Okay.
783E.
Okay. I don't know, let me see, let me think about it.
No, never.
Absolutely approved.
Approved.
Mazel tov.
Thank you. And 783F.
Approved.
Approved.
Are you going to frame this? Okay, that being the end of business, no further business. Thank you, everyone.
Thank you.
Thank you.
Memorable.